We in Kentucky have a very similar story. This is Susie Heck. Susie's story was in the, I forget which edition it was, but in the Kentucky Exceptional Family Magazine. And Susie, the difference with Susie and Jenny is that Susie had been under state guardianship since she was 18. So as soon as she she was put under state guardianship. So Susie was 22 years old. She had mental and intellectual disability. She wanted a job. She wanted a boyfriend. She wanted to go on vacation. She wanted to move and to choose her housemates. So these are not unreasonable things that people would want in their lives.
It's like what most 22-year-olds.
Right. She's pretty typical for a 22-year-old or below or above, really. And so because things weren't really working for Susie, her team contacted P&A. And at that time, we were really just starting the project that we call My Choice Kentucky, which is a collaborative project between HDI and P&A, where we work with people to educate their teams and the community more broadly about support decision making and alternatives to guardianship. So she got involved with our project. She again was lucky enough to be put in touch with a psychologist who was able to submit a report to the court that focused on the things that she could do rather than the things that she couldn't do.
And I'll make note of the psychologist in particular. This was someone who knew Susie, who worked with her, opposed to an appointed IDT member who meets the person, and their job is to evaluate that individual and to make a determination whether they're disabled or not disabled within an hour's time. This is someone who knew her, who had more information than you would through the normal process through the IDT, which is why why we did that.
Yeah. And in that report, she again focused on her strengths, but also talked about how she makes decisions, how she uses her team to make decisions. And in Jenny's case, the psychologist that did her report that submitted to the court was not someone who had seen her regularly, but it was someone who was willing to take the time to go beyond the standardized tests and just followed Jenny around for a while and watched how she navigated the world and watched how she made decisions and saw what she, watched her, take the bus and go to a restaurant and just do, regular daily things to see that she could do this stuff on her own. And she wasn't in any danger while she was doing those things. Anyway, so the county attorney asked, I don't know what that means.
Asked to dismiss the case. So instead of moving forward with either a bench hearing, they just didn't feel like that the case even needed to be heard. They were just like, let's dismiss it.
So the case, so the case was that Susie had filed a petition to have her guardianship terminated. And the county attorney asked for it to be dismissed, at which point P&A requested that counsel be assigned to Susie.
Which in the normal process, once a petition's filed, a modification, then a counsel would be appointed to the respondent. However, in this case, it didn't happen. They were moving forth and decisions were being made by the county attorney to dismiss without her even having appointed legal counsel. So that's when we intervened and requested that counsel be appointed.
She filed a petition, but the county attorney was just ignoring it instead of doing the 30-day, 60-day.
Well, they were doing 30 and 60-day, but at that they didn't do what normally they would have. They were there within 30 days or 60 days, but they didn't appoint the counsel, and they were just wanting to dismiss it.
Gotcha.
So Jenny, Susie didn't have any representation, basically, and she was lucky with the appointment of her attorney because her attorney was willing to come and meet with the team and learn about supported decision making and look at how Susie made decisions we showed her her dream board, which is, I'll go back, and that's what she's showing here. So this is a dream board or a vision board, and she put it on a cork board, and it's got the side with her standing there with her team, just basically has her goals on it. You might be able to see that there are some dates on there. So she's got short-term and long-term goals on there. She's got the people that are important to her on there. On the other side, she had her team on there. So the people that are on her team helping her make decisions. And so anyway, they made this, they took it to court.
And let me go back to the cork board. Part of the reason it's cork board is exactly what Laura was touching on earlier. Goals change, team members change in all of our lives. My goals are very different today than they were a couple of years ago in members of my support team. So that's what's great about the cork board, because of the flexibility and the easiness of being able to create new goals and be able to easily place them on your dream board. So
yeah, and I just saw Susie last week, and she was saying she's in the middle of updating hers because she just got another new boyfriend. She's been through quite a few of them. So she made her original board, but so she's updated some of the things. You know, one of the things was that she wanted to move into a different type of housing. She's done that, so that's off now. So, you know, things change, and you achieve some goals, and you change some, you add some. So that's why it's a cork board. So anyway, so we met with the appointed attorney, and she did her dream board and went to court. Same judge who had, you know, they were all ready to dismiss the case. Same everything, and put this case forward, and her rights were fully restored. And we were quite frankly just going to be happy with with a limited guardianship, but he fully restored her rights.
and she's very successful, you know, to this day.
Extremely successful. She's doing really well. She's really active in the community. Yeah, she's really great. Sometimes when you see her, she'll act like she's a little salty, but really she's she's a very happy young lady. So, I mean, that's like, she's even lost a lot of weight since this picture was taken. She just looks and acts so much healthier and happier than she was before. And like Jenny in Susie's case, she really had all these things working for her before it was formalized and named. So before we move on, I want to talk about a couple of our other folks. Dawn is another lady that we've worked with, and she has used supported decision-making to stay out of guardianship. She was wanted to make a housing decision that her family did not agree with. And so they were threatening to get guardianship for her. And she didn't want that. She didn't need it. She was just making a choice that was different than what they wanted. So she has put in place her supported decision-making team. She made a dream board. She did all that stuff. Finally convinced her family, to let her move forward with this decision. She made this housing change, and it's literally changed her life. So that's a good example of how somebody can make a choice that's different than the one you would want to make, and it turns out really well. Every choice she makes doesn't turn out really well, but this one has. She now lives with a family home provider who she's really close to, and she's very much a member of that family. They go on vacations together. She's gotten a job that she likes. At that job, she was having trouble with people, with her supervisor when the management changed, cutting her hours and not letting her do the things that she was supposed to be doing as part of her job. And she was able to advocate for herself and get that fixed. She did ask for help. She did ask for other people to even come with her while she talked to her supervisor, but she initiated all that and she got it fixed. And so now she's working the number of hours she wanted in the job that she wanted. And just a lot of things. She's just very happy, engaged,
and empowered.
Person.
I
Very
think supported
empowered.
Decision making empowered her.
Yeah.
And that's where.
And even her family, like, she doesn't let her family control what she does. She makes her own choices, and she makes for the most part, pretty wise decisions. It's not as if she's going out making poor decisions for herself.
Better decisions than me.
She makes a lot of really good decisions. So that's one person who's used supported decision-making to stay out of guardianship. And we have one other case where someone's rights have been restored by presenting supported decision-making to the court. And we've got 3 other somewhat pending cases that we're working with to use supported decision-making to have people's rights restored. And 2 of those are state guardians. 2 of those are state guardians. The previous 2 were also both state guardians, and 1 is private guardian. And we'll go into too much detail about that one, but it is a situation where mother got guardianship at 18 because she was told she had to, has since decided, they both decided that this is not something that they need. They've been to court before to try to get it modified and have been, it's just not gone well. And so now we're working with them, and actually Kevin from Protection Advocacy is representing him. So it's just another important thing to know is that once you get guardianship, your life is then in the court's hands. The court decides whether or not the guardianship can be removed. The court decides who the guardian should be. The court can decide that the person that brings the petition isn't suitable to be the guardian and can assign someone else, which could be very well be someone the person doesn't know. And in the case of full guardianship, it's forever. It's until you go back to the court to ask for it to be modified, and even then it might not happen, just like in this other case that we're working with. So it's very difficult to get out of, which is why, we'll talk about it a little bit more, but limited guardianship should be considered if it is decided guardianship is needed, because it does expire after 5 years. It can be extended, but it is set to expire after 5 years. So anyway, the National Guardianship Association actually supports the use of supported decision-making and other alternatives, and suggests that it should be used prior to guardianship proceedings starting. There are a couple of states now that have laws on the books that say this, that alternatives have to be explored before guardianship is pursued. Kentucky is not one of those states, but there are a few now. And then they also say, as we've been talking about, when guardianship is needed, that it should be as limited as possible and allow maximum retention of the individual's rights. So even if a guardianship is needed, use supported decision-making, and that is basically what they're saying. All right, so we're going to talk about guardianship now. All right, so guardian is a person who looks after and is legally responsible for someone who is unable to manage their own affairs, especially an incompetent or disabled person or a child whose parents have died. And we're going to talk about adult guardianship primarily, well, pretty much exclusively.
Yes.
And so people with intellectual and developmental disabilities and the aging population are the 2 big groups that are in this, have this status. And every state has its own guardianship statutes. It's different from state to state, which is why it can be difficult to understand. Sometimes the terminology is even different from state to state. So a lot of people think that the guardian is has absolute power over the person, but that's actually not the way it's supposed to work. Of course, the way the statutes are written and the way it's practiced can be different. But they're supposed to assure that the personal, civil, and human rights are protected. You're supposed to start with the premise that the individual should participate to the maximum extent of their abilities and act in his or her own behalf when making choices and decisions. So that's just what we were talking about before, making sure that a person is involved in the decisions that are made about them. They're supposed to look after their health, safety, and welfare, and we've already talked about how supported decision-making alternatives can aid in that. And it has to be individualized. You can't do the same thing for, if you have 10 wards or 50 wards or 70 wards, you can't treat them all the same. Everyone is different, and they need
And decision-making process is different.
Decision-making process for different, the communication skills for different people is different. I mean, you have to make it individualized. Before guardianship is sought and even after, we need to ask some questions. What are the individual's abilities? So a lot of times in the guardianship proceedings, it's very much about what the person can't do. But there are going to be a lot of things that person can do, so make sure you're looking at that. Can they take care of their own personal needs for health, food, clothing, or shelter? Can they manage their personal financial resources? There are probably some people in this room that aren't really great at managing their own personal financial resources.
Talk about me.
Maybe. Are they going to be taken advantage of? Are there alternatives available? And there's one tool that you should all have. It's called the practical tool. And this was developed by the ABA for lawyers, but it's actually something that can be used by anyone. And practical is an acronym: presume, reason, ask, community, team, identify abilities, challenges, appoint, and limit. So this is a really handy worksheet that you can use, even though it says it's for attorneys. It doesn't have to be. That kind of helps you think through, does this person need a guardian? What are their abilities? What are their strengths? What challenges are presented? Are there resources in the community that can help meet the challenges? Is the team already in place? If not, who can be on the team? And the very last one, the L, is limit. And that's, if you decide guardianship is necessary, make sure that it's limited to only the things the person really does need that much help with. So I think this is a good tool. A lot of other people have found it useful. There's also a link on the bottom of the page that can take you to, there's a larger resource guide that goes with this. Or if you just Google ABA practical tool, you'll find it. But this is helpful, I think, for a lot of people just to kind of stop and systematically think through why a person may or may not need a guardian. And we've kind of already covered this, but you can use a practical tool to do this. Think about why guardianship is needed. If it's needed, are you filing for guardianship because someone said you need to file for guardianship? What does it mean? You need to know what it means to be a person's guardian. Someone told me, I'm my child's guardian, and now I have to file a bunch of paperwork to do all the stuff I was already doing. But a lot of people don't tell you there's a lot of paperwork involved with being a guardian. So that's one thing. Think about the duration of a guardianship. If you're getting full guardianship, like I said, that's not going away till possibly you petition the court, and maybe not even then. So that's, again, limited guardianship can be important thing to consider, and really, I think, underutilized in Kentucky and nationally. You can get just a couple of, just one or two areas filled. Yeah, question.
What do you do about school districts, because people with intellectual disabilities can stay in school to 21. What do you do about school districts that say, oh, they're 18, they're now legal, if they don't want you in the room, you can't come to IEP?
So the question was, what do you do about school systems? Because school systems frequently require, really, parents to have guardianship over their child as soon as they turn 18 in order to be involved in their school meetings and things like that. And there are a lot of things you can do about that. You can get, if it, the first thing you can do is there's the law that they're citing there is the FERPA law, which I apologize that I don't remember what the acronym is, but it's FERPA. There's a FERPA release, just like you would send a HIPAA release. I used to work in the financial aid department of a different college, and we use them all the time. Colleges use these all the time. It's the same law. It's just where the student signs a form that says, these people can have access to my records and attend my meetings, and they name the people and they name what they can do. And that's it. Those things already exist.
Are there other things in case for example, I can think of a situation where the school could have convinced the individual that you don't need your parents in these meetings. And
That would be interesting. I hadn't heard
No,
heard it the other way a lot. But,
Those aren't the calls we get.
yeah,
Those aren't the calls we get. It's usually a parent.
it's usually the
I
opposite.
know the school didn't do it.
Yeah.
Well, the school
it's-
was trying to convince our son, that's why we got.
Right.
Guardianship.
Oh wow, that's interesting.
They
And
were trying
usually,
to convince him, you don't need your parents. And it's because we were very vocal and active
Oh, yeah.
and demanded our
Yeah.
rights. And, he's an 18-year-old,
Right.
And he sometimes would be, oh yeah, I want you to meet.
right. Well, and you can get limited guardianship just over education, like educational decisions. Yeah.
And one of the things that Laura and I, My Choice Kentucky, we're getting ready to expand it with some grant money that we are receiving through the Commonwealth Council on Developmental Disabilities. And the part that Laura is over is education of supported decision making, but to address topics like that as well. And educators is one of the biggest
one of the
groups
target
that
groups,
we're
yeah.
looking at, as well as the Wings group, which is a stakeholder group for persons that are looking at reform and the guardianship in Kentucky, and of course there are wings groups in other states as well. So I do think in the next couple of years you're going to see a lot of efforts out there to educate educators specifically on that issue.
But can you go to the courts now and get an educational guardianship?
You can
It
also
used to just be conservator.
You could always do it's like she said with
it's just-
guardianship. It could be just over education. I mean, you could get a limited guardianship.
Most people think it's an all or nothing thing, but it's not. You can get limited. I would say the only danger would be that
You'd get full.
you'd get full. So you can petition just to get limited, but they can decide that you need full.
Does the student not just have the right to have anybody at the IUP or whatever meeting?
Yep.
that they-
Right. But then in this case, it sounds like this, which is usually the opposite of what we hear. The
Right.
school is trying to convince the student that the parents
your mom
don't
can't
need to be
come.
there anymore. So, yeah.
Yeah, I mean, they would do things like be worried about his safety. Well, he was fine walking to school. And so they'd be like, well, we need to get buses and someone needs to pick him up and do this. And we'd be like, no, he can do that stuff by himself. But then they would let him go to some classes that he could do well in, so he could be,
Right.
so they're just difficult.
Yeah.
This was 20 years ago.
Yeah. And usually we hear the opposite thing being said is that they're trying to force guardianship, saying you can't come unless you do this, and not giving the student, not presenting that option that the student has of allowing whoever they want to come.
And I think it's a lot of it is just education. It's needed. I mean, I believe that teachers truly believe what they're saying, and that a person can't attend unless they have legal guardianship. And so that's what we have to get out there. And Laura and I actually, over the past couple of years, we have gone and spoke to some educators in Montgomery County. I don't remember.
Yeah.
But so those efforts will be in hopefully full force
Yeah.
at some point.
Get you up to Northern Kentucky.
Okay.
We're a traveling roadshow. Yeah, question online?
Bill Dolan says that FERPA stands for the Family Educational Rights and Privacy Act.
Thank you for our attorney consultant online for.
You probably Googled it. I was kidding.
Did you Google that, Bill? Thank you, Bill. So yeah. So
Yes, indeed.
do it.
At least he's honest.
It's true. Yeah, so you can get another thing that a lot of people are concerned about are finances. So you can be just a conservator for someone. So you just have control over that aspect of their lives. If you control a person's finances, you can control a lot of things. But and some people, we've worked with some people who they don't really want to deal with their finances because it can get really complicated, especially when you have benefits. And I have to say Carolyn Wheeler because I don't know. I just ask Carolyn when I have these questions. And so that can get really complicated.
I still always advocate that then a rep pay would be appropriate in that case, because that way you don't lose your total rights and control over your finance. You still maintain some control. So, but yet you have somebody who's in that position that can help you manage. So I still promote, for the person to maintain that right and just have a representative pay through Social Security.
The courts are often more comfortable with the conservator,
Courts are
but
out of there if you don't.
yeah, if you
have- that's
get,
what's-
yeah, if you don't have if you just have a rep PA, not a conservative, then you don't have to worry about the courts at all. So that's a good thing, because you still have paperwork if you're a conservator and reporting duties and all that. So yeah, it can just be over one or two or however many specific areas of need. All right. And so there are other alternatives and things that there's supported decision making, which we've obviously been talking about, and a lot of these things that you can use within supported decision making. So skills training, if there's something specific, one specific area that the person needs to work on, that's fine. Even lower than or with the rep pay, you could have be a co-signer for a bank account. Can have set up again, contact Carolyn Wheeler, trust fund, special needs trust.
Your stable accounts.
You can get a stable account. Could have a power of attorney, and you don't actually need an attorney to establish a power of attorney, nor do you need to be an attorney to be involved in that. Until your mom.
Depends on what your mom says.
Unless your mom says you do. Representative payee that we've discussed, support decision making, obviously, and then healthcare, surrogate or living will. And a lot of these things, powers of attorney and living wills and all those things are things that most of us need to have anyway in place. And these are all things that just already exist. It's not a special thing that needs to be created. These are things that are already out there that people can utilize. So I think that is, I'm done.
That over here. So the reason, I don't know, so now we're talking about guardianship, and Laura touched on it when we first started. The reason we wanted to start out with, God, my pen's falling apart, with supported decision making is we really are trying to promote that is an alternative to guardianship. So we need to think about supported decision making first as an alternative prior to thinking about guardianship. And we're not saying, neither of us are saying that guardianship isn't appropriate at times. We have just experienced that it is overutilized. And so we believe that if we go into looking at a person who might benefit from guardianship, we start with the premise that what can they do? What can we put into place to prevent the guardianship? So that's what is so key about what I think we're trying to achieve today is let's think these things first. And then we talk about guardianship as a last resort.
Yeah, so don't automatically go because the person has developmental and intellectual disability and they've turned 18 that they automatically need a guardian. Think through, like the first P, the P in practical is presumed guardianship is not needed. So start from that point, work through it, and then maybe at the end you'll decide that it is needed.
So the rest of the presentation is just some basics on guardianship as well as what the role of guardianship is. I find it very beneficial that when I meet with groups to really go over what the statutory and regulatory language is, because I always find that people are very surprised what the laws actually say in terms of what the role of guardianship is. The other thing I wanted to talk about before we get into that is Laura and I, we keep referencing this collaborative project that her and I are working on, My Choice Kentucky, and I referenced the grant that we just recently received. Part of that grant is not just educating, and we hope to educate the attorneys and judges, anybody that'll listen to us really will educate parents, individuals with disabilities, number one. But the other piece of that, because that's only about half of what we're doing with that grant. The other half is P&A, Kevin Sharkey, is going to be assisting us. He's in the room, for those of you who can't see. He is going to be supporting me in this venture where we will actually be representing some individuals. I'll still be providing some technical assistance to attorneys, but then we're actually going to have a number of individuals that we're going to provide the appointed counsel to in these proceedings. We find that often, and the reason for this, and I can't remember if we go into this later, is the language in terms of when there's some confusion in the courts, not just by attorneys and it's all parties, including judges, on who, when a respondent, their appointed attorney, that is in statute. There are judges and other parties who believe or assume or are not clear on if it's a guardian ad litem, which is a person who is normally appointed to do best interest as an attorney, but then an appointed counsel would be someone who is advocating for that individual, for what they're wanting. So they're taking direction and lead from their client, the respondent, which is what P&A feels that role of that appointed attorney is, versus the guardian ad litem, who would be more best interest, which is really, we don't feel like is an appropriate role, because that person's rights are getting ready to be stripped. And they have, I mean, we really feel strong that they should have a right to counsel who are going to protect their rights the best that they can through these proceedings. So that's one way that we feel that we can get into is to educate, is to actually provide representation for these individuals in hopes of educating different courts throughout the state. So there is a small number, so don't everybody start calling us today because it's a small grant. But you know, if you have more questions, you can contact me at P&A, and you know, we're hoping to collaborate even with state guardianship with Dell in this venture.
The other advantage is that even when you have an attorney who is more than willing to work with a client, an appointed attorney like Susie had, it's still a matter of that attorney getting up to speed on the fact that there are alternatives to guardianship and what they are and how they work. Or Kevin is now already an expert in that, and we'll have lots of practice in arguing that in court and in dealing with that. So that would be an advantage to those people that they're representing as well.
Yeah, we were pretty lucky with the appointment for Susie. The attorney was just wonderful. She was very open to the conversation, and I think she felt very enlightened. And I'm hoping that she continues to practice these particular cases with that information, with supported decision making with her clients.